years, but it actually never realized what IDEA stood for. So it's the Individuals with Disabilities Education Act. And to qualify under IDEA, there are three prongs of eligibility. So you have to meet one of 14 eligibility categories. Yeah, the Idaho Special Education Manual will lead you through all of those items, but autism spectrum disorder, intellectual disabilities, traumatic brain injuries, multiple disabilities, specific learning disabilities, so disabilities in reading, math, health impairments. Other health impairments is usually where our students with ADHD fall under those categories. You may end up with orthopedic impairments, and there's a variety of eligibility categories there where nursing care may be needed. So that's one piece is have one of the 14 eligibility categories. The other piece is that the disability actually has an academic impact, that there's an impact in regards to attending school, obtaining performance relative to same age peers, having a being able to access your education, and the disability is having an impact in regards to being able to participate in the academic curriculum. And the other part is that the student requires specially designed instruction. So there is some instruction necessary as far as academics, behavior support, etc., that the student needs. These eligibilities are done with a school psychologist and an evaluation team at the schools. This is something really quickly when looking at Section 504 and IDEA. It's worthy to know, especially for nurses. There's something that I like to call special education island. With Section 504 plans and IDEA IEPs, you should never find yourself alone making decisions. With Section 504 and IDEA, there's always a team helping make decisions for the student. So for any professional that's involved with these teams, you don't ever want to find yourself alone. If you find yourself alone, generally something wrong is happening. Either the team is not engaged, or potentially you're making decisions by yourself. In a role that a nurse would be in as a related service, you usually will have a team around you. So that's to protect the student rights, but also to protect the members of the team. So just a quick aside. Next slide, please. So IDEA, the plans that come from IDEA or IEPs, Individualized Education Programs, and our quick definition, a written statement for each child with a disability developed, reviewed, and revised in a meeting in accordance with the Code of Federal Regulations, and must include statements of the child's current educational performance, have measurable educational goals, and specify the nature of the services that the district will provide. The IEP sets forth the FAPE, which is the free and appropriate public education that's offered to the child with a disability. And if an IEP fails or services fail, quite often that represents a denial of free and appropriate public education for the student. Next slide, please. 504s are slightly different, where an IEP requires having three prongs of eligibility. 504 actually requires basically one, that you end up with a student basically has a mental or physical impairment which substantially limits one or more life activity. So if you have a disability, most often you would be eligible for some version of 504 plans or protection. So there's it's easier potentially to get a 504 plan, but they are different in that one provides, sorry, next slide, please. One provides specialized instructions and supports to allow academic progress, which is specially designed instruction. And the next one is the 504 plans are are access plans. So 504s are 504 is a non-discrimination statute. So a 504 plan is provided for students so they can access their education at the same level as their non-disabled peers. So when you're looking at a 504 plan, an access plan for a student, you're looking at what accessibility accommodations are made. So the starting point is the same as the non-disabled peers in the classroom. Special education, IEPs, it's specially designed instruction, specialized instruction and support. So there is a difference between the two. IEP students are covered under 504 as well, because they are identified as a student with a disability, even though they have a slightly different program and a slightly different plan. They still have the disability, the access protections that students under 504 do. So they still have disability protections. Next slide. Lyndon, do you have anything or? Good.
No, I mean, I guess it's my turn. Um, so, I actually, when Julian asked me to help with the presentation or present some things, I actually ended up giving him like 7 different topics, and I'm sure you guys would be interested in all of them. There was like delegation of services to non-nurses. Some of you nurses who have been doing this a long time, there's that question, tons of questions, and then I could have hit also the recent changes under 504, which are all medically related, right? So unfortunately, we only have 30 minutes. So if we had 30 days, I could probably talk for 30 days on that stuff. So, but if you guys want some of that stuff, let Jocelyn know, I guess, and maybe we can talk about it next year or some other time. So school nurses have obligations to refer students with conditions to evaluate under IDEA or Section 504. And you may not know that. That's very different than just being a nurse, right? A lot of people think nurses just give out medications and things like that. You're actually part of the school. So you have an obligation to report when you think the child may need something. And I'm going to give you a really good true story, good example, great story where essentially the school nurse had a frequent flyer, a kid who just kept coming in, getting bandages and stuff like that. Now, this wasn't a disabled kid, but it should raise some red flags to you when you start seeing a frequent flyer, right? And I'll give you a case about that in the next slide. But so she, after several times of seeing this kid, she looked down one time. She said, "Hey, your shoes are untied, and you need to tie your shoes because you might fall." And she didn't even connect the two things. The kid kept coming in for scrapes and bruises and stuff like that. And the kid looked down and said, "I don't know how to tie my shoes." And she's like, this is a 9-year-old kid in 4th grade. And she's like, "I can't believe," and just in her mind, "I can't believe that he doesn't know how to tie his shoes." And she said, "You don't know how to tie your shoes? Why?" And he said, "I don't, my mom is never around, barely see her. She doesn't teach me. I live with my great grandmother." Think about that, great grandmother. And she just ties my shoes for me. She takes care of everything for me, just like a grandma does, right? Just takes care of everything. They never learned how to tie his shoes. And so she pulled the kid up, spent some time, showed him how to tie his shoes. Didn't get it at first, finally got it. And she got a phone call from great grandma crying on the phone and saying, "Thank you so much for spending the time to teach my great grandson how to tie his shoes." And she said, "I've never seen him so proud of himself coming home and say, 'Nurse Shelley taught me how to tie my shoes. Look, Granny.'" So that is kind of an example, but you'll see that with kids with disabilities. You'll see frequent flyers, and there's reasons why they come in. So role of school nurses, you know this role that you may be required to provide related services, and you may be required to be a member of the IEP team or asked to be. You're not a required member, but when the condition is something where you can provide input on how to assist the child in receiving or accessing accessing their education, you may be asked to join the team, and that's when you give your expertise. Next slide. So child find. So child find was what I was talking about. School nurses may have an obligation to refer students. So when you see that frequent flyer kid, think to yourself, well, why is this kid always showing up? Could be for attention, right? Could be headaches. They constantly have headaches. And you're like, well, this kid's got migraines and they might be missing a lot of education. I might need to refer them. They might need accommodations. Does that make sense? And you probably aren't even thinking about that. So this is the case I'm talking about. School nurse may be the first individual to have a reason to suspect a disability. It's the Yana or Jana case. So interesting facts. I'll just quickly cover some of the notable facts on this. The kid had declining grades, frequent visits to the school nurse, and she suspected, because she saw the kid and suspected some self-harm was happening, right? The court found that this was sufficient. This amount of knowledge by the school nurse was sufficient to trigger the district's child find duty. But if you never report that to the teachers or to the team to evaluate or refer for, you miss this kid, and this kid ends up missing out on their education. So what do we mean by frequent visits? The student visited the nurse at least 54 times that school year, began failing most of her classes, and cut herself during the day. What are you thinking? Why wouldn't you evaluate? So that information, plus the therapy services that they knew the child was already getting, should have prompted them to seek parental consent to do an evaluation. So yes, you have a duty when you see these things, because you may see these things and not report it to anyone. And then how does everyone else know? And there's another case. So the Springer case, the kid had pancreatitis. Okay, so in this case, the school district developed a healthcare plan, which can be appropriate, but I don't have time to get into that. That's another 30 days of me talking about healthcare plans and 504s. Sometimes you're writing too many 504s, and sometimes healthcare plans are more appropriate, where you as the nurse can make those decisions quickly. But there's a process you got to go through, and it can get complicated. But in this case, that's what the school felt was appropriate. Here's the problem. They developed a healthcare plan, and they said, hey, this healthcare plan takes care of her pancreatitis. Here's where they ran afoul. The student had tons of absences. How can you say that your health plan was sufficient if the kid had tons of absences still? Does that make sense? You might have addressed the pancreatitis, but the kid is still not accessing their education. Does that make sense? So that's when, in this case, the hearing officer said, well, wait a second. You still had all these absences. How can you say that was sufficient? There might have been more. You should have at least referred them to discuss whether or not you knew that the child had an underlying medical condition, and you have these absences. You should have referred, right? So I hope that makes sense. Yeah, can't cover the individual healthcare plan and differences between that and a 504. You can limit the number of 504s you write by having individual healthcare plans. I'll cover that in a little another example later. Next slide.
So just to follow up with what Lyndon was saying, it's the district's obligation when we're looking at individual healthcare plans in Section 504. Really where it's at is that the obligation extends beyond just the school nurse. So I mentioned the idea of if you find yourself alone, if there is something that doesn't seem right, or there's a condition that seems to extend beyond just simple, I don't want to say medical care is simple, but when we're talking about the student and the whole environment, the educational environment, that there's something that seems to extend just beyond the medical care that the student needs, make sure that you are looking at involving the entire team, referring across to school administration. In my case, I'm the special education director. My nurses, I have my nursing team here, but we want to make sure that making sure that those concerns are forwarded across. And then looking at related service, and I know Lyndon's chomping at the bit to talk about this one, but I'll bring it up just briefly. For in my situation, my nurses as related services will help out students that are on IEPs where they have an educational program, but they may also need to be tube fed, or they may need suctioning services. I've had students that attend general education classes that have been in medical strollers that are nonverbal and have trachs, but they still are able to attend general education classes, and they will have augmented communication systems, but they really have significant healthcare needs, and they need full-time monitoring. Nurses have always been part of that plan as a related service. Students that would access general education under 504, the nurses in my district will do a lot of diabetic care, a lot of looking at monitoring diabetic care for students, a lot of looking at and making sure medications are there's appropriate medication plans for students, and looking at, again, the concept of if you have a student that maybe is in a wheelchair, but they can access general education. They still they might need healthcare as a related service during the school day. They would take advantage of, say, the nursing care that's in the special education classroom just for a few moments of the day to get whatever needs they have taken care of, and then they would be right back in general education. So as a related service, that's how a lot of times how that approach is. Nursing care kind of fits into the special education system that I deal with. And then I debrief at least every week. Most of the time, it's multiple times a week with my head nurse in the district, and we talk about where the needs are with the students, what we see, what's going on. And then there's a variety of other fabulous school compliance issues as far as immunizations and other things that school nurses get to be involved in, that extend beyond IDEA and Section 504. I'll pass it off to you again, Lyndon.
Cool. Thanks for adding that. So this slide, I'm not going to cover it a lot, but basically it says, is there a difference between IDEA and 504 with regard to related services? Not really. OCR is basically interpreted as the same thing as providing services under the IDEA. And you'll find that with a lot of things where 504 is not clear. So they just end up looking to IDEA, and you can basically fulfill all the requirements under Section 504 by following IDEA. That's all. Next slide. All right, school nursing as related service. A child must be provided school nurse services if it's needed in order to receive FAPE. Okay. Now, interesting that Julian talked about the child with a feeding tube and stuff like that. Here's the actual case, school district Philadelphia. In this case, and it's really tough. And when I represented school districts, some of you know me, I actually gave different advice for small school districts compared to large school districts. And the reason why is because you just don't have the same resources. And if you do the wrong thing, you'll end up like this case, where in this case, the Philadelphia case, kid had a feeding tube, student population of only 1,000 students, I think. I want to say 1,000, 1,300 or something like that. And they only had, of course, one school nurse. And some of you smaller school districts, you have one nurse that runs between all of your schools, right? And so now some people may read this case. So they ended up losing, school district ended up losing because it said that, hey, the hearing officer said, based on the facts and everything, you need to have a one-on-one nurse. How can you afford that? Right? And so I don't read it that way necessarily because it wasn't presented in the right way. And that's a whole different story of not having an attorney that's going to argue on your behalf or just not even get here in the first place. But if you read very closely, really, it says you should have evaluated whether or not the nurse could have made it in time, or if there even was even a high risk of the child aspirating, right? And so that's really, if you read the case closely, the team with the nurse should have evaluated and said, look, the possibility of this kid aspirating is pretty low, and I'll even show you how to fix it. And even if the kid aspirated, in this case, it's all individualized, right? Remember, if they would have had that discussion and said, look, the risk is really low, and this person knows how to clear it, liability is non-existent. I'm pretty sure this hearing officer, well, they discussed it. They talked about the fact that the risk is pretty low, and they taught this person how to handle it. So you don't need a one-on-one nurse. Do you see how minute that difference is? Just having that conversation just now released you of the possibility of having to be ordered now to have a one-on-one nurse. That's why it's so important to have like a good special ed attorney to assist you through this process to say, hey, let's go through all these possibilities. And if we get sued, we're not going to have this very expensive order that says this kid needs a one-on-one. This kid needs a one-on-one nurse. This kid's so student with complex medical needs, similar situation, Prince George case. In that case, again, they failed to do anything. You got to do something. Okay. Kid missed 80 days of school. Right. And so at the end of it, I mean, they're arguing ridiculous stuff. And unfortunately, you put your attorney in that position. They're arguing, but 30 days of the services, it was because of the outside nursing agency didn't have sufficient staff. Not an excuse. That's your responsibility to provide the services to the kid. So ultimately, that's comp ed. Next slide. I'll try to fly through this. Again, not required member. Assessing need versus nice to have. That's where your expertise is going to come in as well. So I didn't want to give you all these cases where they found, hey, the nurse needs to be there. Again, you get to assess because of your medical expertise, like in the last case that I just mentioned, where you can say, look, the risk is pretty low of this kid aspirating. And so there's no problem. So same with this case, the Gwinnett case. This is actually a pretty big case. Concluding that the district did not have to provide student nursing services because they weren't necessary. And the hearing officer or the court found, it just makes them comfortable. And so it's not necessary. The nursing services were not necessary in order for the kid to receive education. The records, the medical records indicated that the kid needed a private bathroom, a water bottle, I believe, and some rest in order to benefit from the education. Court's all like, wait a second, why does the kid need a nurse for that? You see how just doing the assessment, getting it on record, helps you save you from a liability. Diabetic student example, really quick. This is a real case that I mediated, came out with a great resolution. There is a difference between a kindergartner or a first, second, third grader who is diabetic, right? Versus a 16-year-old that is a diabetic, right? And that's the problem where you're not assessing every single year and making changes on the 504 based on their growth, their knowledge, the family's financial situation. In this case, they failed to assess that. Once I assessed it and put it all together, I'm all like, this is a 16-year-old kid. Initially, parents couldn't afford a pump or some way to assess the child's glucose level. Parent got a job, insurance, ended up getting all of that stuff. By the time the kid's 16, he knows how to manage his diabetes, right? So why do you have this extensive 504 plan or medical healthcare plan when he's 16 and he literally needs 3 minutes just before lunch, which they've already calculated on everything for him to inject himself? Why do you have this extensive plan that was basically made when he was 7, right? So that's why it's important for you to be a part of the team as the child gets older and reassess whether it is needed anymore for the child to benefit from his or her education. All right, next slide, and I'll let Julian close.
So we usually hear a lot in nursing, you generally hear a lot about HIPAA. I know we covered a bit about HIPAA and FERPA in our last session, but I wanted to bring up one thing in particular. There's a fabulous joint guidance on the application of FERPA and HIPAA, and I put it's in our references. The guidance. So I would encourage anybody to read it, especially people that are working in the school environment. Really, the summary comes down to that as far as FERPA and HIPAA. So FERPA being educational records. Most medical records, and we're looking at students that are being covered under related services, pretty much all of the records that we're looking at under 504 IEPs and related services are actually covered as educational records, and that they're protected by FERPA, but not HIPAA. So if there's a conflict between those two, in most cases, FERPA in the educational environment overrides HIPAA in schools. It's generally because a school district is not running a health clinic. If a school district is running, say, a clinic of some version where you're actually providing healthcare to students, that it's not part of an IEP or a 504. If you're running literally a health clinic and you are billing insurances and exchanging information, that then HIPAA would apply. But in most cases in a school system, FERPA sits. So this guidance is actually fabulous for anybody working in the education environment, and I encourage all of my school principals to read it, and anyone of my school nurses to read it, especially people that have been out in the clinical environment or out, in an office out in the community, because there's a tendency to go and default in the medical environment directly to HIPAA, but in schools there's FERPA. Privacy still applies, but basically most medical records in the educational environment are covered as educational records, not necessarily treatment records under HIPAA. So that's just the primary thing I wanted to cover. And I did see there is a question in the chat, because we are at the next slide, which is questions, which is where we document if we referred someone that doesn't end up getting placed on a 504. Then this is where, if there is the district should have a place to document referrals for Section 504 and any documents that went into, say, an evaluation. So if there was a referral for 504, there should have been some version of an evaluation team meeting. Those should go in a student's cumulative file. Hopefully not in the trash. I have seen that before. But no, they are educational records, and they should stay in the student's cum file.
So Anna from Boise School District, you just opened a huge can of worms. That is a whole presentation on its own that I'm doing trainings on for school districts. Even if the child does not have a 504 plan, the child is still a child with a disability, correct? And so they still have all the protections under 504. Just because they don't have a 504 plan, they still get all the protections under 504. The problem is some school districts do not have a way of noting that. So they end up expelling the kid when they forgot to even do a manifestation, because they're all like, well, the kid doesn't have a 504 plan. It's still a disabled kid. So they still have protections under 504. So it's a huge can of worms. I have a whole presentation on it, but it's an excellent question. So if you don't have that in your school, you need to ask your IT or whoever it is. Like, we need to note that this kid is a 504 kid. They don't have it's called technically eligible. They're still technically eligible. They just don't need a 504 plan. A good example would be a kid with asthma, for example. So let's say they have an inhaler. Oh, okay, well, that kind of corrects everything they need. They're still a child with a disability, right? So what if you now punish the kid for he forgot his inhaler, and the PE teacher punishes the kid for not running the mile, the full mile, and didn't even know, right? Do you see how that works? So yeah, it's a great question.
So really quickly, just to since I know we're in nursing zone, what Lyndon was referring to is a manifest determination. It's part of IEP and 504 protections. If there's a significant behavior or something that happens that causes a significant discipline event to happen for a student, or if there's a pattern of discipline events and that student has a disability, there's what they call a manifest determination, which just asks two questions. Was the behavior, does it have a direct and substantial relationship to the disability? And was the behavior in question caused by the failure of the district to implement the 504 or IEP? Ostensibly, what it is to ensure that districts aren't punishing a student because of their disability. So that's part of 504 protections. If you have a student that doesn't have a 504 plan, but does have a health issue that qualifies as a disabling condition under Section 504, they become technically eligible. Those students should still be identified by a school district, but then they still get those discipline and non-discrimination protections as if the same as if they had a plan and the same protections as any student that's on an IEP as well.
Thank you. Thank you both. Leanne had her hand raised. If you have a question or comment, I'll let you go. If anyone has additional questions, please put those in the chat and we can have some conversation there.
Thank you, Jocelyn. I think that Julian pretty much said what I wanted to say, just that we had a student who was recently diagnosed with diabetes, and they were having trouble getting all of the people together to have that 504 meeting and to create the plan. And there was some hesitancy on letting the student come to school without the plan in place. And I said, oh no, we could still receive the student and implement the things that the nurse is going to do. We don't necessarily have to have the plan before allowing the child to come to school.
Yeah, so the easiest thing with that is when in doubt, provide the service. Even if a student hasn't gone through the full evaluation or eligibility period, if they need health care, if they need care, you provide it. You can't. It's not like somehow the disability takes a vacation just because we're waiting to do our paperwork. Like, oh, I'm sorry, you just don't have diabetes for a week. You don't need care. That's not true. So there should always, of course, be no one's going to fault the district for providing what they believe is the best care and documenting that they've done that, but they will fault the district if you have a kid show up and they fall into a diabetic coma because nobody did anything. The other thing is you can't deny a student enrollment just because you're not ready to receive a kid with a disability. Students have a right to enroll and attend their schools.